Good afternoon, everyone, and welcome to our inaugural Lunch Out Loud, Finding Our Voices When Democracy is Challenged. This is a first in a series of events that we will host in bringing citizens, experts, and voters together to stay up to date on the latest developments in our democracy and learn how and prepare how to face any challenges. These webinars are sponsored by the ACLU of West Virginia, Common Defense West Virginia, National Association of Social Workers West Virginia, Rise Up WV, West Virginia Citizens Action Group, West Virginia Citizens for Clean Elections, and the West Virginia Faith Table. So you can see a lot of West Virginians coming together to collaborate and help each other out. I'm Natalie Tennant, former West Virginia Secretary of State, and I want to thank you for being here during your lunch hour. Feel free to go ahead and eat, whether you want to do it on camera or off camera. We may see a little bit later. I want you to note that this is an interactive Zoom. So if you have questions, please put them in the chat and we will answer them and get to them. This really is interactive, and we want to be able to hear what you have to say and maybe what kind of ideas and questions you have. I want you to know that I have heard many times from social justice advocates, voting rights advocates, civil rights advocates, that in the recent years, the month of June has the potential to be a very sad month. It's because we wait on the opinions of the U.S. Supreme Court and whether any of our rights will be taken away. Like last year, it was a devastating month with the Roe versus Wade decision handed down that took away women's rights, or the gun case last year in New York that overturned a more than 100-year-old law. Which brings us to this June and why we are here right now. How did our representative democracy fare in the latest Supreme Court term? And what will it mean for ballot access in West Virginia? We are joined by two legal experts, Atiba Ellis, professor of law at Case Western Reserve University of Law, and what we like to say, he's one of us, former professor at WVU School of Law, along with Anthony Tony Magistro. Seems like everybody knows Tony, a Charleston attorney with expertise in election law. And I want to thank you, gentlemen, for joining us for this discussion. I'm looking forward to this Friday afternoon discussion to get us going. And I'm going to start off, in a sense, where we left off back in December. Professor Ellis, you remember that you joined us in a similar webinar the day after the Moore versus Harper case was heard in front of the U.S. Supreme Court justices. That case, also known or called independent state legislature theory case, is about checks and balances and affirming the role of state courts in elections. And it was so concerning that in a rare amicus brief to the Supreme Court, the Conference of Chief Justices, an organization representing current and former chief justices in the 50 states, came together and warned against this theory, arguing that it would oust state courts from their traditional role in reviewing election laws under state constitutions. Now, Professor Ellis, you also filed a brief in that case with the Boston University Center of Antiracist Research, which explains how checks and balances on state legislative activity are crucial to safeguarding the rights of Black voters. Thank you for joining us today. Again, talking about the same case, but maybe with a different approach. I think if the outcome were different, this whole webinar would have a different tone and we'd be talking about different things. But I want you to start off with why the theory was so dangerous, especially as it pertains to the right to vote and challenging restrictive voter suppression laws. And actually how it turned out too.
Right. Well, first of all, thanks for inviting me back. It's a pleasure to get to talk to y'all and to feel, at least virtually, that I'm getting to come back home, like you said earlier, back to West Virginia, my academic home as a tenured professor. So yeah, I would say that it's a good thing that we get to reflect on this in sort of the rearview mirror. But I'll also say that the outcome, and yet spoiler alert, the court struck down the most extreme version of the independent state legislature theory in its opinion in Moore v. Harper. And it did a pretty good job of basically saying the theory as the advocates from North Carolina wanted to see it play out was too extreme, and it did so in a sort of sideways way by saying, this has nothing to do with the kind of history of how democracy has worked in America. This sort of extreme view that, and this is the theory, right? That the elections clause of the Constitution, the claim goes, allows state legislatures to, in this case, partisan gerrymander without having to be accountable to their state courts. So if you missed us in December, let me kind of walk it back to what Secretary Tenet was noting and give you a little bit of the lay of the land, right? So like I said, the theory, the independent state legislature theory, which was, and in fairness, a number of sort of conservative leaning law professors and litigators and legislatures basically had signed on to this idea that the elections clause of the Constitution allows legislatures, state legislatures, to draw districts for federal congressional districts without having to be accountable to the other branches of state government. Their main reason why they made that argument was looking at the text of the elections clause, which, and if I had thought about it, I would have pulled my PowerPoint up and just put it, which I have with the text of it. But the text basically says that the legislature of each state will set the time, places, and manners of elections for federal office. But the federal government can amend those rules as it sees fit. So the independent state legislature theory basically said, well, that text means that it's only state legislatures that can set the rules around elections, including drawing congressional districts, hence the sort of circumstances under which the case came up. In North Carolina, there's a constitutional provision that prevents partisan gerrymandering, but the North Carolina state legislature came up with a heavily gerrymandered set of congressional districts. The North Carolina Supreme Court, which at that time was in the hands of the liberal-leaning part of the judiciary, struck those districts down in a state court litigation. The North Carolina legislature then took it to the Supreme Court and said, hey, independent state legislature theory gives us a pass on what the North Carolina Supreme Court told us was illegal. Now, had it gone the other way and had the court bought the theory, which was a bit of a concern because a number of justices had said in some of the footnotes and some of the opinions from about 2018 through 22, especially in the so-called shadow docket when the Supreme Court's disposing of motions without briefing and without argument, especially in 2020 when there were a lot of fixes that courts had put into place to get around COVID. Some of the justices had said, hey, this is really about legislative powers, so maybe we should just leave it up to legislatures. So kind of sounding like it was the independent state legislature theory. So had it been adopted, notice what would have happened, right? The legislature, in this case, North Carolina, could have drawn the districts and could have ignored the role that the North Carolina Supreme Court would play in that. Now, footnote here, the irony is with the most recent judicial election in North Carolina, the court is now in the hands of the conservatives, and they actually ended up getting the relief that they were looking for in the first place. The court upheld the districts that the legislature wanted. But it's bigger than that, right? The theory, by cutting out the legislature from the other two branches of government in terms of its accountability, would have just let legislatures run amok. And in that brief that my colleagues at the Boston University Center for Antiracist Research and I wrote, we argued that in an era where the Voting Rights Act doesn't mean as much as it used to mean, because Section 5 is ineffective right now, and Section 2 has shrunk in its coverage over the last few years. You know, state courts are essential to hold off partisan gerrymandering, and given, especially in North Carolina, the correlation with Black voters wanting to vote for the Democratic Party, partisan gerrymanders basically end up like racial gerrymanders. So with this 1-2 punch of the federal government not being robust in protections and the independent state legislature theories cutting out state courts, then we would have partisan and racial gerrymanders almost running fully amok. And we argued that this sounds like 100 years ago when the Supreme Court basically did the exact same thing and stepped so far back from regulating state legislatures that it's Jim Crow that we abhor. But moreover, right, the partisan gerrymandering point is an important point in and of itself, that given Ruccio versus Common Cause, a decision from a few years ago, Chief Justice Roberts basically said, even though the federal courts now no longer have a role in policing partisan gerrymandering, it's up to the state courts to do so. And so this decision would have undercut that idea. And so democracy would not have fared well at all in a decision in Moore v. Harper that would have gone the other way. And the final point is, by blowing this up, we wouldn't have known what the scope of it would be, right? Is it just congressional elections, or is it other regulations? Is it about voter ID? Is it about, early voting? What's the scope of the power here? And what role would the federal courts play in this? Do we have to appeal everything to the Supreme Court? Can the federal it would have created far more questions than it would have answered, and created a whole lot of destabilizing effects. And so at the end of the day, Chief Justice Roberts was right in basically arguing that this theory is inconsistent with text, history, and practice.
Yeah. Thank you for laying that out. And, it comes down to checks and balances. As the non-lawyer on this panel, that's what I say. It's just the checks and balances that we learned back in elementary school.
Yes.
And thank you, Professor. And so, Tony, I mean, you've been involved in a lot of cases of redistricting. But I mean, it's now back. The extreme part of the independent state legislature theory was struck down, but that doesn't take away, like the example was North Carolina. Oh, in 2022, they got the majority, the Republican conservative side got the majority back into the Supreme Court. So now it's almost as if their legislature can then answer to that. And you know what it's like to have an extreme legislature. You have followed the West Virginia legislature when it was the majority of both sides. And so you know what that possibility is, because as a professor was talking about, West Virginia's Attorney General and Secretary of State supported this theory. And what can we do, and what will you be looking for as someone who interacts a lot with the legislature? What can we be focusing on, and think about any provisions that might protect us as we move forward, whether it's the state constitution or watching out for any potential pieces of legislation?
Well, first of all, I think there's a lot of be careful what you wish for, and I'll explain a little bit more of that as I go on. But one of the things the North Carolina incident makes clear is it matters who's in the legislature, and it matters who's on your court. We have little control in states as to who's on the U.S. Supreme Court. That's a whole. That would be a week's worth of seminars to solve that problem. But we do have control. We do have more control as citizens of states over who we elect to our legislature and who we elect to our court. And in the North Carolina case, the North Carolina Supreme Court undid what was thought as an extreme legislative gerrymander. Then a shift in the court undid their rulings on finding an extreme. So it's not a panacea for the U.S. Supreme Court to say, we're going to let the state courts take care of this, because we have to be careful what our state courts do and be careful in our litigation there. With respect to the gerrymandering, as is the case in a lot of West Virginia decisions, the seminal case in West Virginia on gerrymandering is a case State ex rel Cooper versus Tennant. I'm not sure who that Tennant woman is, but she seems to have ended up with her name on a lot of decisions. And in that case, and that's another, be careful what you wish for. I argued the side. We had a Democratic legislature, a Democratic governor, and there were challenges to the redistricting. That it was state redistricting. It was not state legislative redistricting, not congressional redistricting. But there were among other challenges, there was a political gerrymandering challenge, and I was part of successfully convincing the court that that is not the kind of thing that the politics of the decisions of how you balance the various competing interests in redistricting is not something that the judiciary should be involved in. And the court in that case said that lacking any authoritative standard by which to definitively judge such matters and absent compelling evidence that any unconstitutional partisan gerrymandering occurred in this matter, no relief is warranted. So they didn't completely close the door to partisan gerrymandering. But that court, which was a Democratic court, was skeptical, and that was pre-Ruccio too. So I suspect any attempt to make a partisan gerrymandering claim in West Virginia in front of our court is going to have Ruccio cited. So I think that's the lesson. That the lesson in all this is that you have to be very careful about these rules that we advocate for and enact, because procedural rules a lot of times swing both ways, and so the protections that the rules may offer you in one case, you may not think you need them, but if there's a change in who the political decision makers are, or who the judicial decision makers are, that may have an impact. In terms of that's, I guess, my West Virginia comment. I think I want to make one more comment on what we avoided by having the Supreme Court reject this theory. There's another provision in the U.S. Constitution in Article 1, Section 1, dealing with how the President of the United States is elected. And what that provision says is each state shall appoint in such manner as the legislature thereof may direct a number of electors, and then it goes on to figuring out how many electoral college members you get. During the last presidential election, there were those who argued that provision allowed state legislators in states that had voted Democratic in the presidential election, but had Republican legislators to just decide they didn't like the way the vote happened and have the legislature appoint electors to the electoral college that were different than the party that the voters picked. I think we would have had an extreme constitutional crisis if that ever happens, where the voters believed that their votes for president were undone. And it's that same term that, as the legislature may direct, that my fear always was that this independent state legislature theory, that they were after more than just redistricting, they were after impacts on things like the presidential election. And that would have been just awful, in my opinion, for democracy.
Well, wasn't that how it started out? Wasn't that what Trump was trying to do in getting some legislatures to think that way? Yes. And I guess I'll throw a curveball in here too, Professor. You can follow up on anything that Tony said. I guess the curveball is there's the new case, not a case, but a suit in Michigan where the Attorney General is now suing or charged. I probably should have looked it up before it came to the top of my head. Those who signed up to be electors or called themselves electors and they weren't in 2020.
Yeah, I believe that's a criminal prosecution, Natalie.
Okay, yeah. So yeah, if you don't know anything about it, don't just tell me so. But that's for the audience and folks listening. That's something to think about too. Professor, did you want to follow up on anything?
Yeah, no, I think that what Attorney Majesto is pointing out is another one of those consequences. And sure, it's worth saying that that shadow docket litigation that I referred to that was right around the 2020 election, I think some of that, and particularly not even making it to the Supreme Court, but maybe some of the lower court litigation, was throwing this idea around that the electors clause in Article 1, to distinguish it from the elections clause, which Moore v. Harper was litigated. Yeah, I think it's part of the same piece. If you basically read this, it's up to the legislature alone into the similar language in both clauses, then yeah, it opens the door, and in its extreme version, thoughts that were said out loud by people that, yeah, a state legislature could just decide its own view of who should be the electors to decide the president, and put that together with Trump openly asking anybody who had power to throw votes his way, as he was recorded and saying in the Georgia, yeah, it would have really brought us to a true constitutional crisis.
I may have asked you to explain and define this the last time we met. Just for folks who are new on here, I see a lot of new names. I see some familiar names too. And audience, as you're listening, feel free to put some questions in there. Explain quickly what shadow docket is, because I feel like we're hearing it more and more. And you two can tell me if that's right, if that's the case, if we're seeing more action of the court using a shadow docket.
Yeah, and I'll start out by saying my colleague at the University of Texas, Steve Vladeck, wrote an excellent book about the Supreme Court and the shadow docket recently. So if you want the deep dive, read his book. But the 30-second version is this. The Supreme Court, we usually hear about it when a case is accepted by the court, it's fully briefed, there are oral arguments in the fall and spring, and usually, as we said at the top of the podcast, come June, most of the decisions roll out, right? So that's the opinions of the court. But usually there are procedural motions and motions for restraining orders or temporary orders that often get put before the court, and then the court, as it's duty bound to do by statute, has to act on those immediately. So if an emergency motion comes up, then the court offers maybe a few pages of opinion, if any, and then that's a decision. Oftentimes, these decisions can then structure the entire case, like winning the temporary order in an election that's going to happen like 2 or 3 days from now, which I remember in like the example freshest in my mind is Wisconsin April 2020 election. The court ruled on when absentee ballots were due. And that ruling happened basically 36 hours before the polls were going to close. So that kind of motion practice that doesn't get argued, that doesn't get briefed more than in a cursory amount, and isn't necessarily open to public deliberation, is what we call the shadow docket.
Okay, that's good. Good to know as we see some of these come about. I particularly think about the Texas abortion piece of legislation.
Mhm.
That I hear a lot on that. Well, let's continue to talk more about the redistricting, and some of them gone through. Maybe Tony and I'll talk a little bit about West Virginia, but let's get to Alabama before we move straight, because it may have some impact. Now, when it was heard, it was the Mulligan versus Merrill case, because John Merrill was the Secretary of State at the time, and now it's Wes Allen, so it's the Mulligan versus Allen case. And if either of you would like to explain it and tell where we are now, Tony, if you wanted to talk about that, and what does that do? I mean, I don't think there's a real connection in West Virginia, but go ahead and explain it, and tell us what happened with that one too. That was a little bit of a surprise coming out of the court.
Well, that was what used to be a typical voting rights case. The allegations in the case were that the state of Alabama had diluted the power of Black voters in drawing its congressional maps. And there was a challenge to that, and that the court below found in favor of the plaintiffs, and ordered the creation of, I believe, 2 majority-minority districts, and essentially telling the state that they had to take race into account based on the Voting Rights Act in drawing these congressional lines. The Supreme Court took the case, and there was a big fear, given the courts, a lot of members of the courts expressed belief that race should be completely ignored. And as we saw, it was not all good news for those of us who tilt a little liberal in terms of the decisions. The court struck down affirmative action in college admissions, said you can't take race into account. But in the Alabama case, they said it was okay, and that they upheld the provision in a 5-4 decision. They upheld that provision of the Voting Rights Act, and so that was a good result. Of course, cases rarely end when the Supreme Court rules. The Supreme Court it has no way of enforcing its orders other than its papers, and they send them back down to the other courts and the parties who should be bound by those decisions to implement them. And so I'll let Professor tell us the rest of the story. What happened on
that's what I want to know too. We were all happy, but what's going on now?
Sure, and I mean, I agree. This is a good outcome as far as it goes, right? That Alabama, and even to flesh it out just a little bit more, we're talking congressional districts. We're talking Alabama, 30% of its population, basically it's like 27 or 28 actually, but I'm just going to say 30 for ease of math, is African American, and Alabama is big enough to be entitled 7 districts. So you do the math. 2 of those districts were argued to be majority African American. So Tony's right. Supreme Court held for it. I think it's worth saying that the law behind it started with this case called Thornburg v. Jingles that the Supreme Court decided in 1986. And in 1986, the court basically said, look, to deal with these racial vote dilution cases, we're going to set up 3 factors, right? Could we come up with a district where the majority in that district would be the minority in question? If you can check that box, then the next question is that minority politically cohesive? Will most of them basically vote the same way? Can you show it by social science data? 3, if those 2 are the case, is there a racial majority that has historically and or currently fighting the minority's influence? And if you can check all 3 of those boxes, then if the district gets flagged, then the court can say, well, under these factors, you broke the law under the Voting Rights Act, and here's how you should deal with it, right? So all of that is to say, the district court in the Milligan case did all that. The Supreme Court said, basically, we affirm it. And the suggestion that Alabama's made that Thornburg v. Jingles test be thrown out, we reject it. This is Congress's place, not ours. It comes back. And basically, over the last month, the Alabama state government has basically said, you know, we might tinker with this map, but we're not really going to change it. And so we're now at this point where, like, and I just pulled it up, so I'm going to look at my other screen for a second to make sure we get the sort of facts. They are going to work on a map, and I think as of July 21st, they basically sent the map, but it's going to require a special session. But basically, Alabama doesn't want to move. So now it's going to require more litigation to basically make the state of Alabama actually comply with this ruling. Now, the other point I want to pull out, and I just pulled this up on democracydocket.com just so that I have the count right, and somewhere around a dozen or so other cases around the country, in Louisiana, for example, we're basically all relying on the Allen ruling to make sure that, hey, we can proceed with a Jingles theory. And so now that the Supreme Court has basically given the green light to Jingles, you're going to see lots of other litigation around the United States, which will probably end up reshaping congressional districts and state legislature districts across the country, and in particularly with congressional districts, given how close the margin was in 2022, the Allen decision opening the way to redistricting arguably in favor for the more liberal leaning side of politics might end up reshaping Congress.
And Tony mentioned this, but there is no, what can the federal government do if Alabama, you know, they have their special session and they still don't do it? You said there'll be a lot more litigation. Would a local group litigate, and then do they hold their own elected officials and have a mandamus that they have to do that? Like what's if it happened in West Virginia, what would we be doing?
Well, ultimately, I think what happens is that when a court holds legislative or congressional districts unconstitutional, they send it back to the legislature with instructions to do it the right way. If that doesn't happen, there is authority, and it's happened many times, for the court itself to draw the districts, and so that's the remedy on that, and that would happen in the trial court that is hearing that case. So that's probably where we're headed now. If the Alabama legislature is going to refuse to do what everybody thinks the Supreme Court ordered it to do, the lower court will probably end up drawing the districts. And that's unfortunate, because really it's not the court's job to do that. It's the responsible legislators ought to know, at least when they're told what the law is, how to follow that order from the court.
Yeah. Folks who are listening in, please put some questions in. I don't think we don't have any question answer, but put it in chat.
While you're looking, I'll just note that, in fact, Democracy Docket has it at 32 Section 2 of the Voting Rights Act lawsuits across 10 states, where groups, including private groups, are asking for challenges to be progressed or revived in light of Allen. So nearly 36 lawsuits out there. And I also think it's fair to say that, in a smaller point to be made, I think the court also made it clear that private parties can bring these lawsuits. It was a throwaway point in the litigation, but making it clear that this is the point of the Voting Rights Act. So it's a small point, but it's an important point because yes, grassroots groups can find standing and get before the court and argue for fair maps.
Okay, I want to bring up something. Tony and I had talked about it a little bit before. There are some elections, we know this, where even if a court, for example, I mean, I guess Alabama is a good example. Yeah, when they had these, there were illegal maps used in the 2022 election 2 years ago. And how does that? Well, I guess if they get it overturned, so they have to have those maps in before 24, right? But in some cases, what happens if the court, and I'm thinking about a case back in the Jefferson County versus Tenet, and West Virginians may remember this one. I was a defendant with Governor Tomlin, Jeff Kessler, who was Senate president at the time, and Rick Thompson, who was Speaker of the House at the time. And actually, Tony Magistro would have been, no, you were defending us, and it was Jefferson County represented by Stephen Skinner, who said that the congressional map was not fair, right? And in that case, then you had lost under, why don't you explain it a little bit better, Tony, than I am, instead of my stammering through it. And then we'll explain a little bit about what Tony does with a lot of the legislation. So
this was the litigation surrounding the 2010 redistricting. And most of the decisions that are involving our district, state, and or federal, the most recent decisions arose out of that election. Notably, there were no challenges to the redistricting, either state or congressional, this past in the 2020 redistricting. So
why was that?
I think part of it was that with respect to congressional redistricting, in shifting from one district, we lost a district, shifting from 3 to 2. There was a lot less, you either drew the line north and south or east and west, and there was a lot less opportunity to argue about which areas should be in which district, I think, and so I think that had it. The other thing is the series of Tenet decisions. In those decisions, the court was pretty differential to what the legislature did. I had been following it, and some of the state Senate proposals that were passed that didn't become law, I thought were probably in violation of our state constitution. It's such they would be able to be challenged. Senator Trump gave some impassioned speeches to that effect, and who's Senator Trump, who's the Senate Judiciary Chairman, Republican, and the political process resulted in those changing enough that I believed at the time, and still do, that if they had been challenged, the courts would have said the trade-offs in balancing and redistricting are to the legislature within a broad frame. And that was the argument I made in 2010, was the Constitution sets a frame and the legislature gets to draw the picture inside the frame. And so I think that's why there wasn't a challenge. Is I think they might have gotten close to the lines, but I don't think they were over the line. So in back to 2010, the challenge was that the congressional districts that had split up the Eastern Panhandle violated a bunch of different redistricting principles. They convinced the 3-judge panel that was appointed to hear that case that was the case on a 2-1 decision. So we were in, I believe that was January-ish. We are getting ready. Secretary Tenet was in the middle of the filing period. And so here we all of a sudden had our districts declared unconstitutional. My solution to that was to, as one of the lawyers defending the districts, was to seek a stay of that decision, pending the Supreme Court review, which we ultimately convinced the Supreme Court to stay that, and the court held those elections under maps that at least one court had decided was unconstitutional. Now, ultimately, that next September, the court 9-0 said the West Virginia court got it wrong and upheld the districts. But that explains, the problem with this litigation is, especially if you're going all the way to Supreme Court, it takes a while. And in the meantime, you have elections. So you either do elections based on the districts that the legislature passes while they're under challenge, or you end up with some of the shadow docket decisions that Professor was telling us about, that where you have a very different level of review, and it's hard. It's hard to balance all those interests out. Unfortunately, in the West Virginia case, that we ended up, the court upheld the legislature's decision on those districts. So we didn't have a situation where we had an election based on districts that somebody ultimately believed were unconstitutional, which is essentially what has happened in Alabama.
Okay. I bring that up, one, that is where we see, I guess, in 2012, those races were used under that old map. Because I look at some of this research, I researched some of it back then, it was January 3rd. And if I remember correctly, the time frame of when you file to run for office, it's about that second week of January until about the end, whatever that last Saturday is in January. And so here we are, as election officials, you come into the Secretary of State's office to file to run, and depending on where you live, you don't know if you would get to file for a specific district. And that time we still had 3. So that's what goes on. That's what holds up. We think about these court cases, and I know that lawyers who are filing these cases understand, like Tony, especially you do, because you've worked so much in it. What the structure is and the deadline that county clerks have to meet, or Secretary of State for the multi-district filing, and it's not always easy just to say we're going to go to court. I think it's interesting on this time period. Tony and I were on the same side, although personally, like I'm named in it, the governor's named in it, Senate President and Speaker of the House, because that was our position. And I don't know if I ever told you this, Tony, but I was like, this doesn't seem right to me, but I had to defend it as the executive branch of what the legislature gave me. And Tony will say there's several cases that have my name on it only because I was secretary at the time. And actually one of them, it started out when Betty Ireland was secretary before me. And just like in the Alabama case, it changed to my name. So there's a little bit of behind the scenes of what goes on. And we do have a question. I don't know. I know Levi Pellegrin, and I don't know if you want to come on, Levi, or you just want me to ask the question right now. Can you see this, Tony and Professor?
Yes.
Do you think Moore versus Harper increases the invitation of future courts further into the political thicket that Justice Frankfurter warned us about in Baker versus Carr? Are you guys familiar with that case?
Baker versus Carr? Yeah, I think I've heard of that one.
Okay.
Baker versus Carr was the seminal case of the U.S. Supreme Court that is the one man, one vote case, where
which is Jefferson versus Tenet was about, yeah.
Yeah, so it was the case where the Supreme Court got into the issue of how we apportion legislative districts based on population rather than based on geographic things or other things, and require that there be that my vote be the same as your vote, it have the same weight as your vote, instead of we don't have a situation where we have prior to Baker versus Carr, we had, for example, in Kanawha County, would have had the same number of senators as Clay County. And even though the population was 10 or 15 times. And so Baker versus Carr fixed that problem. But Justice Frankfurter offered this caution that the courts were getting into this political thicket. And so, I don't know if it's more or less political. Part of what I would say is the premise behind Moore versus Harper is that when you say a state gets to decide something, or the way something gets to be done, like setting congressional maps, that is done in the frame of the state's constitution, and that the relevant judicial rules apply. And I think one of the important things out of Moore versus Harper is the Chief Justice's opinion left open this idea that a state court could go too far. And if the court, the impression I get from reading that opinion, if a court would go rogue, I mean, legislatures can go rogue, but courts can also go rogue. If a court would go rogue and take what would be, let's say, a redistricting that fits squarely in the middle of the frame of a state's constitution, and then decide for its own political reasons that it didn't like that, and in essence, legislate from the bench, that I think that would be something that a federal court could review under Moore versus Harper. So we have checks and balances all up and down the system, and I think that check and balance of courts going too far and stepping out of their lane is important too.
Professor, I don't know if Levi roamed the halls when you were a professor at WVU or not. I feel like you guys might have been there in the same.
I feel like I recognize his name.
He was probably the troublemaker.
See it again.
Yeah, if anything you want to add to that.
I think that the point Tony made was right. Yet that Moore v. Harper does leave open, and I mean, it is a case that sort of appeals to the ordinary checks and balances. And certainly the check on any state court would be reviewed by a federal court, so long as there is a federal issue. And yeah, I would agree that Moore v. Harper might create a kind of federal issue where the debate between the legislature and the state Supreme Court could then get refereed by the US Supreme Court. And I mean, the point about the dangers of wading into the political thicket that Frankfurter makes in dissent in Baker v. Carr is well taken, to the extent that we kind of look at that as, when it comes to the operation of these checks and balances, and especially creating a place for the court to review what the legislature does, it's probably the closest that the courts come to doing politics without necessarily doing that. That said, I thought about Evanwell v. Abbott from 2016, where the court basically said, we are not questioning the one person, one vote principle at all. And if you recall from that case, the question there was Texas was asking whether it should be, when we think about one person, one vote, we think about, well, which people count in terms of creating the district? Do we use total population, or do we use citizen population or voting age citizen population? Texas wanted to pick one of those others, but the US Supreme Court said basically, since Baker v. Carr, we've been using, total population, and we're not going to change that today because it's well settled. So the danger is there and the concern is there, but Evanwell was an 8-0 decision. I think Moore v. Harper plays against that background, but the court's not going to question that underlying premise.
Okay. Anything else on that, Tony?
Yeah.
Well, I wanted to ask, I don't see any more questions. Let me know if you all have questions. We'll certainly answer that, and I'll tease you at the same time too. So I know Levi's a good sport, but Tony mentioned this earlier, and it ultimately comes down to what can we control? Is we can control the election of our legislature and the election of our state Supreme Courts. And Professor, I wanted to go with you on some of your current research. It focuses how ideology-driven conceptions of wrongful voters diminish the right to vote. So talk about the trends that you are seeing in the state level to criminalize voting process and how those recent decisions position advocates to fight in these measures.
Right. So what I have been of interest lately, and I even have a visual aid. So one of the projects I've been involved in is working on this book, Race, Racism, and American Law. And I've been working on the chapters that focus on the law of democracy. So this is the case supplement, and we are hoping that by this time next year, I'll have the actual textbook to go along with this. So one thing I've been paying attention to in particular is how these things sort of impact along the lines of race. But aside from, and in a way, the redistricting issues are one issue, right? This is the structure in which votes are accounted for, districts are drawn, and what happened. Another layer of this is how people participate. And when we talk about ideological conceptions, this is a fancy way of me saying the voter fraud myth continues to propagate. You know, now we call it election denialism, right? But these things have sort of sped the desire to further criminalize voter level errors more often than not, and turn those into crimes and turn those into felonies that can then disenfranchise people. So if you end up accidentally registering when you're not eligible, or otherwise mistakenly double voting, these sorts of things that might have been either ignored or treated as misdemeanors now become felonies. We're seeing the establishment across various states of election integrity units. Interestingly enough, in the criminal divisions of attorneys general offices, as opposed to within like the Secretary of State's office, because in most states, the Secretary of State, like in West Virginia, is the chief elections officer. But there is this sort of push in, say, Florida and Texas and other states. I even noticed the bill coming up here in Ohio recently to create a voting police force. And I think some of these lawsuits, including sort of the reaffirmation of the Voting Rights Act that was implicit in Merrill, may situate voters to say, hey, if the state's exceeding its bounds, then we still have the Voting Rights Act as an avenue to pursue wrongful actions, because the act is all about what might have the effect of diminishing the right to vote for people of color. Not necessarily looking at the intent of things, but the effect. And so the voter fraud myth continues and is keeping mixing. And this thing also happens on a private level, right? I've been noticing a lot of people engaged in voter intimidation and more lawsuits being brought under other provisions of the Voting Rights Act, aside from Section 2, about voter intimidation. And certainly, even the court in the bad decision, at least from us liberal-leaning point of view, in Shelby County, still said the other provisions of the Voting Rights Act still apply. Section 11B prevents voter intimidation. So when vigilante groups come and watch drop boxes carrying their weapons. That kind of intimidation can be pursued under the Voting Rights Act, can be pursued under federal law, under state law. In fact, full disclosure, I'm an expert in a case around these kinds of issues. So yeah, this is sort of what I've been looking at aside from the gerrymandering level of things.
One thing in West Virginia we have that in terms of these restrictions on the actual voting itself. It's interesting, the US Constitution, there's not that we have lots of rights in the US Constitution and people talk about the right to vote, but there's not an explicit amendment or provision in the Constitution that says a citizen has the right to vote, other than the amendment that grants women the right the franchise. But there's not an explicit right to vote provision. Unlike the US Constitution, the West Virginia Constitution has a bunch of different provisions in Article 4. Article 4, Section 1 says the citizens of the state shall be entitled to vote in all elections held within the counties where they respectively reside. There's an affirmative right to vote. Article 4, Section 3 says no voter during the continuance of an election at which he is entitled to vote during time necessary and convenient for going and returning to the same shall be subject to arrest upon civil process, be compelled to attend any court judicial proceeding as a suitor, juror, or witness, or work upon the public roads, or except in time of war to render military service. So there's these express provisions recognizing the right to vote in the West Virginia Constitution. And I think that would be fertile ground to challenge undue restrictions on the voting franchise in West Virginia. I've always thought that would be an argument, and now the Supreme Court has implied the right to vote in a number of decisions, and Congress has granted express statutory rights to vote in things like the Voting Rights Act. But in terms of an actual state constitutional anchor, and I think we have those in the West Virginia Constitution, if our legislature would try to pass restrictions that would unduly infringe upon citizens' rights.
Yes, that would be an interesting case. Let's hope that you never have to do that.
Again, it's important. Elections matter. It's important who we vote for, and recognizing, of course, what we're talking about is the ability to make your vote count in those elections. So there's that's sort of the trade-off.
Yeah, understood. Good words. Professor, did you have anything final that you wanted to say as we wrap up and finish our lunch hour?
Yeah, I would just simply say that at the end of the day, one, the Supreme Court did not choose to blow up our democracy, which is a positive point. And two, the range of comments about redistricting and gerrymandering and the provisions, including the very important recognition that where the federal Constitution doesn't explicitly guarantee a right to vote or talk about its scope, state constitutions across the country do so. That truly is the starting point for we, the people, to come and protect our right to vote and to encourage our legislators to do the same.
Yeah, thank you. John Doyle gives us a question. Tony, do you want to take it real quick?
Sure.
He's been studying code, of which if this is that John Doyle, there's two John Doyles who are very active. Go ahead. Any reflections on?
Yeah, so John's concern is the code provisions that deal with what particular precinct and poll you would go to, and that under certain circumstances there have been last minute changes, which impairs someone's right to vote. If you show up at George Washington High School and you're told that your polling place is now the Overbrook Elementary School, some number of people who are confused by that maybe don't make it down don't have the time to make it down to what the correct polling place is. I think those are problems when those things happen. My experience, at least in this county, is that when those kinds of changes happen, they try to do a good job of telling people where they're supposed to vote and have that happen. And you always have the option of voting a challenge ballot, which in my experience in this county will at least for the elections that are the same, no matter which poll in varying polling places, your ballot will ultimately get counted. So those are elections are kind of messy sometimes, and I think what we have to be careful about is, and I know Natalie, it was sympathized with this, having to run the election statewide. We've got to have rules and processes and the ability of the elections officials to manage the things that happen that we can't predict. In a perfect world, we would have perfect elections, and that's different from intentionally creating procedures designed to stop people from voting or to stop particular people from voting, whether based on race, political party, or any or which
age,
team you're on, age, any of those things. Everybody should have an equal opportunity to vote. That doesn't mean we're going to have perfect elections, but we should strive to have fair elections.
And I'll just say very briefly that the federal courts recognize that it can have that kind of same effect. There's this case called Purcell.
Right.
And its most important contribution is this idea that courts should not issue rulings that change elections last minute because of the same fear of disruption. Right. So the courts recognize that the federal courts recognize that their opinions could create more confusion than settling concerns. And I agree entirely that in terms of the administration of elections on the local level, that kind of awareness should be true too. Now, emergencies happen. And of course, we should allow emergencies to be resolved. But the line between dealing with the unforeseeable and using tactics to shove away the voters you don't like can be very, very thin. So we have to be careful.
Yeah, very good. And that's a good question too. And perhaps we may be able to address it under an election administration webinar that we have, because we will have more of these lunch out louds coming up soon. One will be about explaining the legislature and what you may encounter when you're there and how you can do citizen lobbying. And we will explain that. I also want us to talk about the electronic registration information system or center, which is called ERIC, which has become a dividing point and a political weapon, which is unfortunate. We'll talk about that in the coming weeks, also in the coming months, also. So, thank you for coming on. It's always good to see you. It's good to talk to you, and always gain your insight. And thank you all for tuning in and spending some of your time with us. I appreciate your being here, and look for us next time. Thank you all. We'll see you.
Thank you, Natalie.
Thank you, Natalie.